Circular 230 is about who can practice before the IRS. The IRS tried to stretch that idea to cover paid tax return preparers, even when they weren't representing anyone in an IRS matter. On the EA exam, they love the line between return preparation and representation. Think, are you just preparing a form, or are you dealing with the IRS on a taxpayer's behalf? Loving v. IRS is the big one. The DC Circuit said the IRS did not have authority to regulate tax return preparers as representatives under the statute. The key reasoning, practice of representatives, is about advocating for taxpayers in front of the IRS, not the mere act of preparing a return. The IRS didn't appeal, so the takeaway stuck. Return prep alone generally isn't practice before the IRS. Here's the exam-friendly way to apply loving. If you're drafting numbers, schedules, and signatures, that's preparation. If you're contacting the IRS to resolve an issue, negotiate, argue, or attend a conference, that's representation. The IRS can regulate practice, representation, much more directly under Circular 230. So always ask, is there an IRS interaction tied to taxpayer rights or liabilities? Sexton versus Hawkins shows loving's ripple effect. Even if someone is a bad actor, the government can't call return preparation practice before the IRS just to regulate it under that label. The case involved James Sexton, a disbarred attorney with serious criminal history. The point for your exam brain. Loving narrowed the definition, so preparing and signing returns isn't automatically practice before the IRS. Now the PTIN fee litigation. In Steele versus United States, a court held the IRS lacked authority to charge a user fee for issuing or renewing PTINs. But that wasn't the end of the story. The PTIN issue was later reversed on appeal, including the Montrois case in the DC Circuit. Exam tip: you don't need deep procedural history. Just know PTIN fees were challenged and later upheld on appeal. Put it all together. Loving limits the IRS from treating return preparers as representatives just because they prepare returns. But once you step into advocacy, talking to the IRS for the taxpayer, signing agreements, appearing at hearings, you're in practice before the IRS territory. On exam questions, the trap is assuming anything tax-related counts. It doesn't. The IRS-facing taxpayer advocacy actions are the giveaway. Which of the following actions does not constitute practice before the IRS? Furnishing information at the request of an IRS employee, signing a closing agreement regarding a tax liability, communicating with the IRS for a taxpayer regarding the taxpayer's rights, or representing a taxpayer at a hearing. Think about it. What's just cooperation versus actual representation? The correct answer is furnishing information at the request of an IRS employee. By itself, that's not practice before the IRS, and it can generally be done by anyone. A tempting wrong choice is communicating with the IRS about a taxpayer's rights. That sounds similar, but it's advocacy on the taxpayer's behalf, which is representation and therefore practice. Which of the following disciplined practitioners may represent clients before the IRS? A practitioner who has been disbarred, a practitioner who has been publicly censured by OPR, a practitioner who has been suspended from practice for 2 years, or none of these individuals may practice before the IRS in any capacity. Think about what each discipline actually restricts. The correct answer is the practitioner who has been publicly censured by OPR. A public censure is essentially a reprimand. It does not, by itself, bar the practitioner from representing clients. The tempting wrong answer is none, because disbarment and suspension do prohibit practice, but censure alone doesn't remove practice rights.